Hey, we got all these brand new Trump-appointed conservative justices who are pro-Second Amendment, and they keep granting all these great pro-Second Amendment rulings. So we're going to be good to go when it comes to the Second Amendment, right? All these cases are going to keep going up there, and all these regulations and restrictions are just going to fall like dominoes. Well, not so fast. What's up, everyone out there? Thank you for watching another episode of Musings with MGL. I'm your host, MGL. What are we going to talk about today? Well, we're going to talk about the Supreme Court and a recent ruling that they came out with as it relates to firearm rights of individuals who have restraining orders. So, quick rundown. As you know, if you have a domestic violence injunction or a restraining order or whatever language your state uses to cover it, that makes you a prohibited person under the federal firearm law. If you are a prohibited person, you cannot purchase or possess a firearm. So currently, the law in America under the federal law is that if you are currently subject to an injunction, not one that expired a long time ago, but if you currently have an injunction against you for domestic violence, you are not permitted to possess a firearm. Well, somebody challenged that law in one of these states that has it because they wanted to say, hey, we should be allowed to have a firearm because the Constitution doesn't say anything like shall not be infringed, comma, unless you have a domestic injunction. And they're challenging it under Bruin. If you remember, Bruin is the big Second Amendment law that the Supreme Court came out with a couple years ago that says if there's no historical reason for having a gun law, then it should get thrown out because it's unconstitutional. So a lot of people were hoping that they would apply Bruin to something like this. But to everybody's surprise, quite frankly, they did not. And let's find out why. U.S. Supreme Court upholds law that prevents domestic abusers from owning guns. The U.S. Supreme Court Friday upheld a federal law that bars people subject to domestic violence restraining orders from owning a firearm in an 8-1 decision. 8-1. Who do you think the dissenter was? I'll give you I'll give you a hint. It rhymes with Clarence Thomas. In an 8-1 decision on United States versus Rahimi, Chief Justice John Roberts, eye roll, wrote an opinion that our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment, Roberts wrote. Justice Clarence Thomas, a staunch advocate of the Second Amendment, was the lone dissent. Thomas argued that the question before the court was not if someone can have their firearm taken away under the Second Amendment, but instead whether the government can strip the Second Amendment right of anyone subject to a protective order, even if he has never been accused or convicted of a crime. It cannot. The White House and gun safety advocates welcome the long-awaited decision of a majority victor. I'm going to ignore all that. This is the first major test of the 22 Supreme Court decision, right? New York versus Bruin. So what does all that mean? Basically, they found themselves a carve out. So as I said, Bruin says that if it's a historical law that's basically been in effect, then it can sustain constitutional muster. If it's not historically an American law, then it can't. So what they did here was they just bold-faced stated that historically America has had laws going all the way back to the Constitution in 1776 that says if people were a danger to other people, that their firearm rights could be suspended and taken away on a temporary basis. I don't necessarily think that that's true, but they say that it is, and if you probably read the entire opinion, I'm sure they cite laws in there and stuff about that. So the main thing I want to let people know is, number one, if you have an injunction against you, you still can't possess a firearm, so that law has not been overturned. But this is an indication that it's not going to be this steamrolling effect that we were all hoping it was going to be after Bruin was passed. Bruin was a big decision, and you saw a few things after Bruin get thrown out. And then we thought, well, now everything's going to basically get thrown out. But don't be so fast to think that. Like I said, Clarence Thomas was the only dissenter. So Amy Coney Barrett, like all these other, quote, conservative Trump-appointed people, all three of the Trump-appointed people voted in favor of keeping this in place. So I don't want people to get overexcited and think that this Supreme Court is going to just be knocking down all these laws, because I think this makes it clear that they're not going to. There's a couple other ones that they even refuse to take up on appeal, meaning that they're not going to address the issue at all, and they're going to let the lower court decision stand, which is against the Second Amendment. So the party's over in the sense of what's going to happen with all of these laws. You may see some that they really care about. For example, I think it's possible that when if a marijuana one gets up in front of them that says people who have a marijuana conviction on their record or are using medical marijuana can't have a firearm, that you may see that get thrown out because there's not going to be any sort of public backlash to that. But there would certainly be a public backlash to domestic violence abusers having firearms. And again, I'm not advocating that somebody who is a domestic violence abuser, I'm not in favor of them having a firearm. I understand that they're dangerous. However, I also understand, as somebody who does domestic violence injunctions on a regular basis, that those things get handed out like candy, that lots of judges grant these domestic violence injunctions like willy-nilly because they're doing a lot of CYA action, because they're afraid if they don't grant the injunction, then if the person does go out and kill somebody, then all of a sudden the news is going to be putting a camera in their face saying, hey, why didn't you grant that injunction? A lot of these injunctions just get granted because the person doesn't show up, because people don't understand what the implications of an injunction are. So a woman, and I'm just going to be stereotypical here because statistically speaking, it's usually a woman filing them against a man. So if the woman files them against the man and the man says, you know what, I don't want to talk to that bitch anyway because I hate her, so F it, get an injunction on me. Well, guess what? You're agreeing to an injunction, but they don't realize that the injunction says that you can't have firearms. Even though it's written in there, most people just say, oh, I don't want to talk to her anyway, so I don't care about an injunction. I have seen people go into court and be talked into accepting an injunction by a judge. I've seen people go into court and be unrepresented and be steamrolled by other lawyers because they don't know the rules of evidence. I've seen people get injunctions against them that were clearly only put in place for things like a temporary stopgap. So, for example, a lot of people, if they're going through a divorce, there's some nasty stuff going on with divorce. Maybe some nasty text messages get sent out. People are coming over in the middle of the night and knocking on doors. And so what a lot of judges will do is say, you know what, I'm just going to grant an injunction for 3 months because I see that their divorce is pending. They have a mediation set, next month on their divorce. So I'm going to grant an injunction for 3 months just to let everybody calm down. And then hopefully their divorce will take care of it all, because they don't think there's any implication. What's the big deal? So you can't have a gun for 3 months. You can't have contact with 3 months. So I'm just going to grant it for a short-term period to let the parties cool off. But that's not what domestic injunctions are for. They are for people who are legitimately in danger and think that they need court protection to help them. And as we all know, an injunction is just a freaking piece of paper. If you're a psycho and you want to shoot your ex, a piece of paper ain't going to stop you from doing that. You're just going to shoot your ex. It doesn't matter whether they have a piece of paper or not. So I'm not saying that people who legitimately beat up their spouses, that I'm marching around going, give them a gun, give them a gun. I'm taking the position I always take which is there's a period in the Second Amendment, shall not be infringed, period. It doesn't say comma unless there's a domestic injunction issued by a local circuit court judge. Like, it's not in the Constitution, so I think it's an unconstitutional law. But I also have a concern with this particular law because I've seen how the domestic injunction system can be abused on a regular basis. So that's why I have concern about this particular law as well from a criminal defense attorney standpoint who also does family law and domestic injunctions. So, but I'm just giving everybody the heads up. If you have an injunction, you still can't have a gun, and don't get too excited about this Supreme Court, because I think this makes it clear that they are not going to go full on and start just steamrolling and repealing all these laws, that a lot of the laws that we have on the books today are going to stay on the books regardless of who all's on the Supreme Court. So that's your lesson for today. Thanks for watching. Please like, share, subscribe to the channel, comment down below. It really helps the algorithm. Being a gun channel, Facebook's always effing with me with the algorithm. So please, any help you can give me would be great. So thanks as always. So for now, stay safe, stay healthy, and as always, Carry on.